Thank you, Lord. Just before lunch, I had moved on to the Advocate General's submission at paragraph 59 of his case, at page EF 107, where he'd submitted that the Welsh asbestos case hadn't purported to create any different approach from imperial tobacco, and said that nothing in the judgment indicated that a requirement of direct connection is imposed. My position is that is not correct. Lord Mann's expressly reformulated words used in Martin against Most to include a requirement of directness. He didn't disagree with Lord Walker and Lord Hope that a loose and consequential connection would not be sufficient, but he and the majority of this court held that this was not an exhaustive description of circumstances in which a law will relate to a designated matter. I say that his reasoning and the ratio of the case turned on the fact that the purpose and effect of the Welsh law was not closely and directly related to a conferred competence. Indeed, it is not difficult to see why directness was at the heart of the reasoning, given the difficulty characterising the law as only loosely or consequentially related to funding the NHS. And finally, the Advocate General complained that Lord Mance's words are taken out of context. I would say they are not. Their context reinforces the view that directness and closeness were highly important in determining whether the law related to the funding of health services in Wales. Moreover, I say there's no reason to suggest that Lord Mance's reference to directness cannot be taken from the context of the case than there is to take Lord Walker's references to loose and consequential from the context of that particular case. And I would point out that Lord Mance's approach to the use of directness is entirely consistent with that expressed by President Lord Reid when he sat in the Inner House in the Imperial Tobacco case. And it's also consistent with what Lord Brodie said in his speech also. The Imperial Tobacco case in the Inner House is in tab 5 of the first volume of Authorities, and Lord Reid's speech is at page EF 588. That's the part where he starts to deal with section 29 of the Scotland Act. Lord Reid begins by referring to Lord Walker at paragraph 119, and thereafter at paragraph 120 explains that the relevant rules are contained in a number of provisions in the Scotland Act and makes specific reference to section 29. And he says it's necessary at this point to consider section 29(2)(b) and 3. As I have explained, section 29(2) states that a provision is outside the competence of the Scottish Parliament if it relates to reserved matters. And he quotes again from Martin against Most at paragraph 49. Thereafter, Lord Reid says, I respectfully agree. In ordinary English, relates to does not mean the same as affects, and although it is a wide expression, it cannot be intended to give such wide construction as to invalidate all legislation affecting matters listed in Schedule 5, however slight, indirect or remote the effect may be. The practical considerations which led to that conclusion in the case law relating to Canada, Australia and Northern Ireland are equally cogent in the context of the Scotland Act. At paragraph 121, he went on to say, deciding whether legislation relates to a reserved matter involves two stages. First, determining the meaning of the words defining the reserved matter, and secondly, determining whether the legislation relates to that matter. At the first stage, it is to be noted that the Scotland Act doesn't adopt a double enumeration model, but defines the Scottish Parliament's powers by implication. as what remains once reserved matters have been excluded. It follows that, unlike the position in Canada, the interpretation of the reserved matters should not reflect any assumption as to the extent of matters which are not reserved.
This is all, I mean, I remember this coming back to this is quite an early case, and it's against the background of arguments where people were trying to rely on authorities and approaches adopted in other jurisdictions,
that's right.
Such as Canada and Australia and indeed Ireland. And I think we were trying to explain how the position under the Scotland Act differed from those under other schemes.
Yes, so that's certainly what my Lord is dealing with there at 121, but I think it is important to look to what he said immediately before that, which is that in ordinary English, relates to doesn't mean the same as affects, and although it's wide, it can't be intended to give a wide construction as to invalidate all legislation affecting matters listed in Schedule 5. And the words my Lord used are, however slight, indirect or remote the effect may be. And certainly the issue about how you deal with the Scottish legislation against the background of the position in Canada and Australia was relevant. But what my Lord went on to say in paragraph 123 was this, that Schedule 5 listed matters, not purposes. Since the question whether a provision relates to a reserved matter is to be determined, read short by reference to its purpose, it appears that the purpose of a provision is to be treated as a pointer to the matter to which it relates. Once the purpose of the provision has been identified, therefore the remaining question is whether the matter to which it points is within the scope of the reserved matters listed in Schedule 5. That question may be straightforward, or it may be more complex depending on the circumstances. At 125, my Lord then went on to say, as Lord Roger observed in Martin against Most, the purpose of a provision will often be clear from its context in the Act in question. The Court can also consider extrinsic material which is relevant to ascertaining the purposes which the provision enacted to achieve. As Lord Hope indicated at paragraph 25, the Court is also expressly required to have regard to the effect of the provision. But what I think is important is when we go over to paragraph 133, we see how my Lord brings all of that together. And if I take my Lord to that, in the context of the Imperial Tobacco case that dealt with the display of tobacco products and the effort made by the legislature to reduce the attractiveness of these to children, at 133 my Lord said this, I've set out the terms of Section 1. It begins by prohibiting the display of tobacco products in places where such products are sold, subject to a discretion conferred on the Scottish ministers by subsection 4, to provide that no offence is committed by display which complies with prescribed requirements. It then provides a limited exception in respect of tobacconists, subsection 2, again subject to compliance with any requirements which may be prescribed by the Scottish ministers. It also provides a general exception in respect of wholesalers, and again subject to compliance with any requirements which may be prescribed by the Scottish ministers. My Lord said the legal effect of Section 1 is therefore to establish a statutory basis for the regulation by Scottish ministers of the display of tobacco products in places where such products are sold. Its short-term practical consequences will depend, in the first instance, upon how Scottish ministers exercise their regulatory powers. The Court is not equipped to predict the ultimate long-term effects of the provision, nor does it require to do so in order to identify the purpose of Section 1. The extrinsic material indicates that the purpose of Section 1 was to enable Scottish ministers to take steps which might render tobacco products less visible to potential consumers and thereby achieve the reduction in sales and thus in smoking. The legal effect is consistent with that purpose. So I say, my Lord here specifically in his speech and in his analysis drew the attention to the requirement of directness as an element of the test. And that's also consistent just with a small part of what my Lord said in paragraph 124.
What I was addressing in 133 was it set out in 132, it was the argument that the purpose of the provisions was the protection of health. I mean, this was effectively restrictions on display of cigarettes, and but the purpose was the protection of health, which was a reserved matter. And the approach I took to it, as you've just shown, was to say, well, was to look at more immediate purposes rather than an ultimate purpose, which who knows whether or not it would be achieved.
Yes, I understand that from my Lord's reasoning. But what's interesting is certainly the attention to detail and the need to understand whether it was more than an incidental or indirect effect. And that was really something that my Lord also touched on when he was dealing with a slightly different matter in paragraph 124. Because in that paragraph, my Lord was dealing with a situation where a provision is enacted to achieve a number of objectives, and it might relate to more than just one matter that's reserved. I think the language my Lord used here is also important. So I think in 124, my Lord was saying in particular, although section 29.3 refers to the purpose of the provision in the singular, in real life legislation may be enacted in order to achieve a number of objectives. In such a situation, it may be unrealistic to regard a provision as relating only to a single matter, and it's possible that in such a situation, one of the matters to which it relates may be reserved, and another may not. And at that point, my Lord borrowed the hypothetical example given by Lord Roger in Martin against Most, and it was a very obvious example of where simultaneously one might be dealing with a devolved and reserved matter. I don't need to go into that. Goes on to say this though, unlike the position in Canada, where legislation must be characterised as relating to only one predominant matter in order to avoid a conflict between the two lists, it may be arguable that the court is not driven by the logic of the Scotland Act to follow that approach. I would therefore wish to reserve my opinion as to the correctness of the argument of counsel for the respondent, that even if the provisions in issue relate in more than a merely incidental or indirect manner to the regulation of the sale of goods to consumers, they are nevertheless within devolved competence because the predominant purpose is the protection of health. Now, we're looking at a slightly different aspect here, but again, my Lord turns to looking at this language of incidental or indirect, and that's exactly how Lord Mance approached the issue in the Welsh Asbestos Case. He was looking for a directness as an element to the test, and I think that's also consistent with what Lord Brodie said at page EF 623 to 624 at paragraph 202. It's really at the bottom of that paragraph, at the bottom of page 623, when he's dealing with the provision that relates to reserved matters. And at the bottom of 623, he said, a provision may, and indeed probably will, have a variety of effects, some more remote than others. In such a case, it is the more proximate or direct or crucial effect that's of importance. Incidental effects are to be disregarded. As was put in the passage from W&A MacArthur Limited against Queensland, quoted by Lord Walker in his opinion in Martin against Most, we have to determine in each case what is the subject of the legislation, what the subject of the Act with respect to, what it affects, not things or operations it may indirectly affect. So that I say that rather than Lord Mance's approach being an outlier or inconsistent with that expressed by others. It's entirely consistent with what his approach is entirely consistent with the way in which my Lord and Lord Brodie approached the matter in the Imperial Tobacco case in the Inner House. There was no criticism of this approach at all by Lord Hope in the House of Lords, and it's important to have regard to when we think about the way in which we approach the reservations in the Scotland Act and just how we deal with the question of the subject matter, whether or not it concerns subject matter of a devolved or reserved power. So I say that further consideration to this particular issue was given by this court in the Continuity Bill case. That's authority at tab 11, volume 1, and at EF 822. And that was a case in which this court held that a bill of the Scottish Parliament would only relate to the reserved matter of international relations if, by its terms, it sought to disrupt or interfere with the conduct of international relations by the UK government. The court stated that there is relatively little scope for Scottish legislation to relate to international relations unless such legislation were to purport to deal with the power of ministers of the Crown to exercise its prerogative in foreign affairs or create a state of law in Scotland which affected the effectual exercise of that power. And that's at paragraph 32 of that decision. It's also, I'll just get the page, EF 837. I think it's also helpful, though, to look at paragraph 33 of that judgment. So, 837. Yeah. So I quoted there in paragraph 30, but then in paragraph 33, it's very helpful to look there at what the court lists in relation to the proposed legislation that does or does not have the necessary connection or effect. And it says at paragraph 33, in our judgment, the Scottish Bill does not relate to relations with the EU. It will take effect at a time when there will be no legal relations with the EU unless a further treaty is made with the EU. And then lists the things that the bill doesn't do. The Scottish Bill does not purport to deal with any legal rule affecting the power of ministers of the Crown to negotiate such a treaty, or otherwise to conduct the UK's relations with the EU. It doesn't purport to affect the way in which current negotiations between the UK and the EU are conducted. It simply regulates the legal consequences in Scotland of the cessation of EU law as a source of domestic law relating to devolved matters, which will result from the withdrawal from the EU already authorised by the UK Parliament. This is something the Scottish Parliament is competent to do, provided that it does so consistently with the powers reserved in the Scotland Act to the UK Parliament and with legislation and rules of law protected under Schedule 4, and 2, that its legislation does not relate to other reserved matters. Parts of the argument of the UK law officers appear to suggest a wider objection that separate Scottish legislation about the consequences of withdrawal is legally untidy, politically inconvenient, or redundant in the light of corresponding UK legislation. But we are not concerned with supposed objections of this kind, which go to the wisdom of the legislation and not its competence. So the court in continuity, the court's reasoning in continuity, placed considerable emphasis on the need for there to be some form of practical or legal effect or impact of the law on the reserved matter. That is entirely consistent and in accordance with the approach taken in the Welsh asbestos case, and with the same way in which my Lord approached matters in the Imperial Tobacco case. And I see it's implicit in the reasoning of the court in the legal continuity reference that from that it's reasonable to suggest that holding an advisory referendum on an issue of international affairs would not relate to a reserved matter by the Scottish Parliament. The Advocate General objects that in my written case I didn't relevantly address the Christian Institute case. But that case, I say, doesn't assist in the submissions made by the Advocate General on this point. The case is at EF 771, Authority Tab 10, Volume 1. For the purposes of this reference...
What was the page number again, sorry?
EF 771.
Thank you very much indeed. Thank you.
Tab 10 in Volume 1. For the purposes of this reference, the relevant issue in the Christian Institute case was whether data sharing provisions in Part 4 of the Children and Young People Scotland Act, which made provision for a named person service to young people, were outside the competence because they related to the Data Protective Directive, which was reserved to the UK Parliament. The Act created a duty to share information about the well-being of children, which did not depend on the consideration of whether it would have been objectively relevant or necessary for that information to be shared. And that's paragraph 16, page EF 778. The court found that although there was a bespoke regime of data processing under the Children and Young People Act 2014, it didn't relate to the Data Protection Act or the Data Protection Directive, the subject matter of which was specifically reserved, because it was not truly distinct from the overall purpose of promoting the well-being of children. You can find that in paragraphs 64 to 66, EF 805. This case then, the Christian Institute case, turned on an identification of the core purpose of the legislation, and provisions in relation to data sharing were not to be treated as being distinct from the core purpose. There is, however, nothing in that reasoning that affects the points that I have made. It's true that the Christian Institute case is the Martin against most phraseology that's used and said to represent a well-established approach. You can see that in paragraph 63 on the last line and paragraph 29 at EF 791. But the additional facet introduced by the Welsh asbestos case was not addressed or apparently identified by the court. So, on the basis of these authorities, in my submission, it would seem that a matter will only relate to a reserved matter within the meaning of section 29(2)(b in circumstances where its purpose is directly and closely related to a reserved matter, probably in this context requiring some actual practical effect, such as imposing some practical restriction or impediment on the pursuit of a reserved matter with an indirect, loose or consequential connection being insufficient. So I now turn to the arguments for the proposition that Section 2 relates to the Union before turning to the arguments against that proposition and for the alternative, that is, that Section 2 would not, by virtue of the reservation paragraph 1b of Schedule 5, be beyond the legislative competence of the Scottish Parliament. The argument that the referred provisions of the proposed bill relate to the Union I can take reasonably briefly, given that the Advocate General has set out the case in detail and maintains that this is the correct analysis of the law. I say there's no real difficulty as to what the reserved matter means. Whilst I noted the incongruity in the statute referring to the union of England and Scotland rather than the union of the United Kingdom, including Northern Ireland, nothing turns on this. The union is a legal union between what were formerly politically and legally independent kingdoms. The purpose of this being reserved is equally clear. The purpose of the provisions in paragraph 1 of Schedule 5 in reserving matters relating to certain aspects of the Constitution is that the matters in which the United Kingdom as a whole has an interest should continue to be the responsibility of the UK Parliament at Westminster. And the relevant authorities that I would refer to in that regard are Imperial Tobacco at paragraph 29, Lord Hope of Craighead, with whom the other members of the court agreed. That's at page 645. And that was the point repeated in the Christian Institute case, where again Lord Reid said a similar thing at paragraph 65. Again in authorities at page EP 805. The different arguments turn not on any difference of view or uncertainty as to the meaning of the union. Rather, they turn on what it means for legislation to relate to the union. The argument against competence has essentially 5 elements. The first is this: the subject matter of the referendum question, asking whether Scotland should be an independent country, concerns the unions of the kingdoms of Scotland and England. The question asks voters to express their opinion on whether they want the union to continue. That, however, does not resolve the issue, just as it didn't resolve the issue in Christian Institute case, that the subject matter of the provisions in question was data protection. The subject matter in the provisions in the Welsh asbestos case was raising money for the health service. And as the court explained in legal continuity case, legislation relating to international relations would not, by dint of its subject matter alone, relate to the reserved matter of international relations. Secondly, as we've seen, there have been a number of judicial statements in this court to the effect that a provision will relate to a reserved matter where the purpose of the provision has a more than loose and consequential connection to it. Again, referring to there, Martin against Most at paragraph 49, Lord Walker on page of the electronic bundle of 406, Imperial Tobacco, paragraph 16, Lord Cope at EP 640, and the Legal Continuity Bill, paragraph 27, again electronic number 835, and also to the earlier arguments I made before in relation to legal continuity at paragraph 33.
I see you referred us a moment ago to paragraph 65 of Christian Institute.
Yes. Yes, I think that's it.
Just looking at that, the first sentence may be of some relevance.
Yes. I'll just get that on Lord.
It's on page 805.
Yes. And my Lord said the first...
the first sentence struck me as possibly being of some significance if we're trying to apply these provisions about reserved matters.
Yes, so there it says it's important to bear in mind the central aim of the provisions in the Scotland Act concerning reserved matters, explained in paragraph 28, that matters in which the UK has a whole interest should continue to be the responsibility of the UK Parliament. Yeah. That's right.
Yeah.
Yeah.
So the Union and Parliament itself are obviously examples.
I'm so sorry, my Lord.
So the matters listed in Schedule 5, such as the Union and the Parliament of the UK, are are obviously examples of matters in which the UK as a whole has an interest.
Yes, I see that, Lord. And I suppose it's the question, and I'll come on to talk about this a little later, is whether or not legislating about the union is enough to meet the relates to test when the referendum is about a matter that's reserved. I think that it might be relevant to think that's the intention of the UK Parliament in creating reserved matters is not to be taken to prevent the Scottish Parliament asking the people of Scotland about matters of importance to the Scottish people, even if reserved. It might be thought that the intention of the constitutional arrangement reflected in the Scotland Act was to prevent the Scottish Parliament unilaterally changing law and matters that are the responsibility of the UK as a whole. And the important thing would be to question whether or not the case law points to the need for some sort of direct rather than consequential practical effect. So if we have simply an advisory referendum, we're not actually taking out of the UK as a whole the step that would be necessary to give effect to the outcome of any advisory referendum. I think that's the important issue that might be raised in connection with the undoubted statement about the purpose of the reservations and the protection of the integrity of the UK Parliament. So I was dealing with the arguments against competence, and the third one that I would point to is that although the immediate purpose or direct object of the proposed bill is simply to ascertain the wishes of the Scottish electorate on the question of independence, a wide variety of background materials, which are admissible aids to identifying the purpose of legal provision, and refer to Martin against Most at paragraph 25 there, electronic folder at page 397, that establishes that this is intended by the Scottish Government to be a step towards independence from the United Kingdom. So the background materials certainly identify the purpose of a legal provision, and that's relevant here. Thus, the argument is that the bill is intended to fulfil a manifesto commitment of the Scottish Government, which stated that the SNP was clear that the referendum must be capable of bringing about independence. And that's reflected in the SNP manifesto, which we have lodged, and it's at page EF 6361, tab 112 in volume 9.
Again, I'm terribly sorry. What was the page number in?
6361.
Thank you.
It's the SNP Manifesto, Scotland's Future, Scotland's Choice, 2021, and the reference is page 12 in that document. And also the Scottish Government's Programme for Government 2021 to 2022 likewise refers to the Scottish Government obtaining a democratic mandate from the people of Scotland to pursue the opportunity of being an independent country. And that's reflected in the First Minister's foreword in the Programme for Government 2021 to 2022 at pages 6426 and through to 6430. Fourthly, as to effect, the proposed bill would have the legal effect, among other things, of authorising election officials to administer a vote and allocating resources to them to do so on whether the union should end. It is therefore arguable that it is not devoid of any legal consequences. Fifthly, although the referendum would have no legal effect on the union, the practical effect of a vote would be politically significant. That point was recognised by the majority in Miller at paragraph 124, which is in volume 5 of the Authorities, number 57, and it said that whilst the referendum leaving the EU had no legal effects, That way in no way means it's devoid of effect. And the page number there is 3429 in relation to that quote. Indeed, the case went on to say, on the contrary, it was said to be of great political significance. At paragraph 125 of Miller, this court quotes from the House of Lords Constitution Committee in its 12th report, 2009-10, Referendums in the UK, House of Lords paper 99, stated that even where a referendum is advisory only, it would be difficult for Parliament to ignore a decisive expression of public opinion. And that quote comes from page 5900 in the electronic bundle and is at paragraph 197 of the House of Lords Committee report. So taking these points together, there is a clear and cogent argument that the Scottish Parliament doesn't have the power to enact a law providing for an independence referendum. The Union is a matter in which the whole of the United Kingdom has an interest and for which the UK Parliament retains primary constitutional responsibility. A referendum on Scottish independence would have more than a loose or consequential connection with the reserved matter of the Union, because the purpose of such a referendum would include that of obtaining support for the creation of a Scottish state and the independence of Scotland from the United Kingdom. So,
I understand the arguments that have been put forward by you on both sides of the equation, leaving a state of indecision, and so that you can't advise one way or the other. Well, you can't positively advise that a Section 31 statement can be made.
yes.
But looking at individual matters which are raised, for instance, political significance, do you submit that it hasn't got political significance, or you say it's an irrelevant factor? Or,
I say, be realistic about it. It does have political significance, just as the vote in relation to the withdrawal from the EU for UK had great political significance. But ultimately, when it comes to determining the purpose of the provision and its legal effect, the political fallout of that is irrelevant for this court. And that's really in line with what this court has said in Continuity Bill at paragraph 11 and indeed at paragraph 33, where the wisdom of the provision is not for this court. The politics of the issue is not for this court. And it's just as Lord Hope said in when he mentioned the fact that the question of political motivation is a different issue. So the politics of this, yes, we can see that it would have a political effect, but ultimately for this court is deciding a question of law, in respect of which they do not take account of the political effect of any vote that would arise from Scotland in relation to an advisory referendum. That has to be the approach, and it's certainly the approach that this court has spoken about frequently in the way in which they deal with these often sensitive constitutional matters.
and accordingly, paragraph 124 of Miller has to be read.
Yes, that's right. And I think what was important in the Miller case was what Lord Neuberger said about what would then follow on from the advisory referendum, which is that there would have to be a vote in Parliament, and the members of Parliament were duty-bound constitutionally to vote on that. I can't quite remember his words as to how they should vote, but they certainly had a constitutional responsibility to vote in relation to that matter, as to whether or not they approved or otherwise of the decision of the referendum. Yes, and Miller...
I do apologise, but you also referred to the background materials. Are those background materials admissible?
So I think when one looks at the I think paragraph 25 of Martin against Most,
Yes.
and the discussion in Imperial Tobacco in the Inner House and in the House of Lords, they are relevant to inform the whole circumstances. They would be relevant to your consideration as to the effect in all the circumstances. Certainly they would. That's why I refer to them here. They are relevant materials. Yeah. But I think Miller wasn't looking at the purpose of the referendum under the Scotland Act. It was looking at something else when it was being discussed in that case. But there's no question about the background being relevant, but ultimately the decision of this court is a decision that has to be one on a purely legal basis, and it is a legal question for this court. So I now turn to the argument that the Scottish Parliament does have competence to legislate for the referendum. As I've explained, in the anticipation of the focus of the Advocate General submission, I'll spend more time looking at this argument, and I submit 6 strands to it. Firstly, the statutory test set out in section 29(3) is expressly directed to ascertaining whether the purpose of a provision, having regard in particular to its effect, relates to a reserved matter. The focus is not on the subject matter of the question asked of the population. It's therefore not sufficient to establish the requisite nexus between a legislative measure and a reserved matter, that the legislation concerns the reserved subject matter, or, in the context of a referendum, that it asks people about that subject matter. Secondly, this court has held that there must be a direct connection and sufficiently close connection between the purpose of a provision and a reserved matter. And I refer to paragraph 27 of the Welsh asbestos case, which I've looked at previously. It's at page 735 of the electronic folder. Further, the reasoning of this court in Legal Continuity Bill, to the effect that the bill of the Scottish Parliament would only relate to the reserved matter of international relations if by its terms it sought to disrupt or interfere with the conduct of international relations by the UK government, also suggests that the connection between an advisory referendum and a reserved matter would be insufficiently close and direct. As we've already seen, the court stated that there is relatively little scope for Scottish legislation to relate to international relations, unless such legislation were to purport to deal with the powers of the Ministers of the Crown to exercise its prerogative in foreign affairs, or to create a state of law in Scotland which affected the effectual exercise of that power. That was what we saw in the authority when we looked at paragraph 32, and again I'd refer to pages 837 and 838. In Continuity Bill, the court's reasoning emphasised the need for there to be some form of legal or direct practical effect of the law on the reserved matter for it to relate to that matter. Thirdly, if the exercise of identifying the purpose of a provision for the purposes of excluding legislation from the Scottish Parliament's competence by reference to section 29(3) is analogous to that adopted in the familiar process of statutory construction, that suggests a narrower rather than a wider purpose, being the legally relevant purpose. And in that respect, I refer to the case of Quinte Valley against the Secretary of State for Health.
I'm so sorry, I didn't catch that.
Yes. R. Quinte Valley against the Secretary of State for Health, which is Authority 49, and it's page EF 2931 and EF 2941. I'm referring from there to paragraph 8 of that judgment, EF 2941, where it says the court's task within permissible bounds of interpretation is to give effect to Parliament's purpose. And I quote there from Lord Bingham. So,
might it not be said that the concept of purpose in Section 29(3) of the Scotland Act is a little bit broader than the rather more precise idea of parliamentary purpose or intention, which one uses when actually interpreting an act? Doesn't it allow one or require one to have regard to a broader concept of purpose than one would use strictly for identifying the meaning of the statute itself? I've just got it at the back of my mind, for instance, when one's applying convention rights in the context of parliamentary legislation, you ask questions which arise under the convention rights, such as what is the aim or purpose of the legislation, and for that usually you can have regard not just to the words of the statute but to the sort of wider context in which the statute has been passed. Isn't it a similar exercise under Section 29(3)?
Well, I think that what's important is to say we're identifying the purpose of a statutory provision, and it's reasonable enough to look at the canons of the legal the cases that have looked at the process of statutory construction in looking at this Act. So it is important, I think, by way of analogy and by way of informing the process that this court has to go through in order to understand what's the purpose provision in Section 29(3) is, to look at how this court has, in previous cases, considered two particular canons of statutory construction as being relevant. And I do say that it is important to have regard to Quinta Valley, for example. I know that Lord Reid made reference to the case Quinta Valley in the Inner House when he was looking at the way in which to approach the statutory construction in terms of the Scotland Act. And there are two particular statutory constructions that are relevant and should be noticed. So the first is this, that the purpose of a law is in the first instance to be derived from an examination of the words used, including any clause that expressly refers to its purpose. And in that regard, I would cite Bloomsbury International Limited against the Department for Environment, Food and Rural Affairs at paragraphs 10 through to 11. That's at the electronic folder beginning at page 3109 and the particular quote at 3120 I rely on is at paragraphs 10 to 11. And that was Lord Mance, with whom Lord Walker, Baroness Hales and Lord Collins agreed. So that case looked at the question of how you look at the statutory provision that related to the landing of fish in the UK, and whether or not you looked at the question of, you interpreted the word landing by considering whether or not you only looked at those fish landed directly on UK soil or through imports or other sources. So the purpose of the legislation was of particular import in the Bloomsbury case. In addition to that, the second point that I would make from the two particular canons of statutory construction that I rely on comes from the case R against the Secretary of State for the Environment, Transport the Regions, ex parte Spath Home Limited, which is 2001 appeal cases, authorities at 46. The electronic pages are 285, and the quotes that I'm going to rely on are at page 2857 to 2862. In that particular case, the meaning attributed to the words of an instrument is an objective question and not to be equated with the subjective intention of the minister or other persons who promoted the legislation, nor equated with individual members or even a majority of members of the legislature. As noted by reference to legal continuity bill, in the context of preserved matters, the purpose of a provision may extend beyond its legal effect, but it's not necessarily the same thing as political motivation. So I think that whilst there is obviously some care to be taken on applying those canons of construction, I do say that they point to the legally relevant purpose of the proposed bill being the holding of a referendum to ascertain the views of the people of Scotland on the issue of independence, and not the motivations and wider aspirations of the individual parliamentarians or members of the Scottish Government. And I would remind the Court that Section 1 of the bill, the purpose provision in the bill, is that it's to make provision for ascertaining the views of the people of Scotland. That is the purpose of the bill, and it's clearly stated. The purpose doesn't extend to securing independence. The purpose of the bill is to ascertain the views of the people of Scotland. Ascertaining those views is, in this bill, the legally relevant purpose, and it would not relate to the reservation of the Union in paragraph 1b of Schedule 5. The question that would be posed to the Scottish people is neutral between a yes and a no vote. The terms of the proposed question are therefore neutral as to whether Scotland should be independent. The form of the question to be used is to be approved by the Electoral Commission, and it is the same form of question that was used in the 2014 referendum. Section 2.5 of the Referendum Scotland Act, which we've looked at, which is at EF 2175, would require the Electoral Commission to consider the wording of the question and publish a statement as to its intelligibility as soon as practicable after the introduction of the bill. And more generally, the proposed bill is not directed at any particular outcome. Indeed, the general provisions on the conduct of the referendum, which are adopted in the bill by Section 4, are directed towards ensuring a fair and balanced campaign. Such a bill could be supported by parliamentarians and others who want the Scottish voters to reject independence. So the question to be posed is neutral. And therefore the motivations and wider ambitions of the Scottish Government represent a subjective intention which is not to be equated with the objective purpose of the bill. The objective purpose is clearly stated in Section 1, that is to ascertain the views of the people of Scotland. That is the objective purpose of any provision which sanctions the holding of a referendum. The purpose is not changed by the motivations of those seeking to hold the referendum. Fourthly, I say that Section 29.3 requires particular attention to be given to the effect of a provision. The limited legal and practical effect of a bill to hold an advisory referendum can be said to support the view that the purpose of such an instrument is to ascertain the views of the people of Scotland that relates to the Union in only an indirect or consequential way. So the legal effects of the bill would be limited to the facilitating the holding of a referendum vote, identifying those eligible to vote, the timing of the vote, and the affirming that the Referendum Scotland Act 2020 would apply. The bill would not purport to alter or impede any legal rule constituting or affecting the union of the kingdoms of Scotland and England, either directly or indirectly. The referendum would have no prescribed legal consequences arising from its result. It is not, unlike some other referendums, self-executing. For example, the 2011 referendum on the parliamentary voting system. The Advocate General refers to the legal effects in terms of organising and holding of a referendum. I say that these can be argued as not being legally relevant effects. They would only be relevant legal effects if the reserved matter was the holding of a referendum. But as we've seen, holding referendums is not reserved. To the extent that the Advocate General points to the authority conferred upon returning officers and the like. In no way can those be said to be anything other than loosely and consequently connected to the reservation in paragraph 1b of Schedule 5. Beyond the immediate effect of ascertaining the will of the people of Scotland, the practical effects of an advisory referendum are properly characterised as speculative, and there is authority that speculative consequences do not establish the requisite nexus required by section 29(2)c. My Lord Reid in Imperial Tobacco emphasised that the courts are not equipped to speculate on what consequences will follow the enactment of laws beyond those that they prescribe. He stated at paragraph 133, electronic folder 592, that the court is not equipped to predict the ultimate long-term effects of the provision. Furthermore, it can be argued that it would also not be constitutionally appropriate for this court to take account of the possibility of future legislation of the UK Parliament. In Yalland and others, at paragraph 19, Lord Justice Lloyd Jones and Justice Lewis in the Divisional Court emphasised that the court should not seek to second-guess whether legislation will be passed by the UK Parliament. At paragraph 19, he said whether any legislation is to be introduced and the form that any legislation should take is a matter for Parliament itself and not a matter for the courts. And to similar effect, Sir John Donaldson, Master of the Rolls, in R against Her Majesty's Advocate, Treasury ex partes medley, 1985, Queen's Bench, at page 666 C to D, which is at page 2667 of the folder, said it behoves the courts to be ever sensitive to the paramount need to refrain from trespassing on the province of Parliament. Likewise, this court cannot second-guess the UK's Parliament's responses if a referendum returned a result in favour of independence. As Lord Neuberger stressed in Muhan, parliamentarians are not bound to vote in accordance with the outcome of a referendum. So therefore, in referring to the effect of a provision in section 29(3), the UK Parliament should be presumed to have meant the direct effects prescribed by the terms of the legislation, and in any event, not effects that are contingent or dependent on future legislation to be enacted by the UK Parliament. And further, the following other points can be made about the wider effects of the proposed bill. Firstly, the consequences attendant on the outcome of the referendum would be political. The Government of the United Kingdom has given no assurance or undertaking as to how it would act if the referendum returned was a yes vote. Even if a majority of voters were in favour of independence, then the practical realisation of independence would be dependent on political decisions and actions of a number of independent parties and bodies, in particular the Scottish Government, the Scottish Parliament, the UK Government and the UK Parliament. As I've just mentioned in Muhan, Lord Neuberger explained at paragraph 47 that if the issue came before the UK Parliament following a Scottish vote for independence, members of the UK Parliament would be free, indeed constitutionally bound, to vote as they saw fit. And the fifth strand to the argument is that the objection that the aim of Schedule 5 is to reserve to the UK Parliament matters of concern to the entire UK, and comments made by the UK Government in the 1997 White Paper concerning the integrity of the United Kingdom can be answered really in much the same way. The holding of a purely advisory referendum does not take the question of the Union out of the hands of the UK Parliament, nor does it purport to do so. The 1997 White Paper did not address the question of referendums, and it cannot be taken as suggesting that the Scottish Government is precluded from ascertaining the views of the population of Scotland on any subject matter reserved to the UK Parliament. Sixthly, other features of the Scotland Act do support argument in favour of an advisory referendum being within competence. Firstly, it is a necessary implication of the devolution established by the Scotland Act that the Scottish Government may negotiate with the UK Government about reserved matters. It is integral to Section 30 of the Scotland Act, by which modifications can be made to, for example, Schedule 5 by order in Council, approved by both houses of the UK Parliament and the Scottish Parliament, that the Scottish Government may have regard to and discuss adjustments to Schedule 5. Given that Section 30 has been used to modify, for example, reservations relating to Export Credits Guarantee Department, there was an order in 1999 and a relevant statutory instrument. And in addition to that, interception of communications and surveillance, and indeed insolvency law, it's implicit that such modifications were approved by the Scottish Parliament, and it's self-evident that the Scottish Government must be empowered to discuss proposed modifications. That is reinforced by Section 63 of the Scotland Act. I have a copy of that section, but that particularly allows for the conferral by order in Council of functions on Scottish ministers beyond the general transfer of competence. So Section 33 is not in the bundle, but I can pass it up after court for my lords and my lady.
I'm so sorry, did you say Section 33?
63. So that allows for the conferral of functions beyond the general transfer of competence. And such an order, if it's to be made under Section 63, requires approval by the Scottish Parliament before it can be made. And the procedures involved in the transfer or conferral of functions is contained in Schedule 7, paragraph 1 of the Act. And I also have a copy of that. So accordingly, it has to be that it's inherent in the entire scheme of devolution that both the Parliament and the Government can consider, discuss, debate and ultimately vote upon proposed changes to the boundaries of legislative and executive competence. In order to exercise such functions in an informed and democratic way, the Government must be able to canvass the views of the people of Scotland on such issues. Reflecting these features of the devolution settlement, political parties can and do campaign in Scottish general elections on policies relating to reserved matters, testing the views of the electorate in general elections on such matters, and taking office on the basis of policies relating to such matters. Most obviously, of course, Scottish independence, but it might relate to any of a large number of reserved matters. There are various examples of the Scottish Parliament debating and passing motions in respect of reserved matters, as was envisaged from the outset of devolution, and I refer to some detail of that in paragraph 45 of my case. So it is significant that the scheme of devolution created by the Scotland Act allows for forms of democratic participation beyond the exercise of the franchise in general elections or ad hoc constituency elections as a means for testing the views of the people of Scotland. By way, for example, Citizens' Assembly of Scotland convened in 2019 and 20, and the Citizens' Assembly on Climate Change in 20 and 21, which was convened under the Climate Change Scotland Act, added Section 9 of the Climate Change Emissions Reductions Targets Scotland Act 2019, added by Section 9, were both exercises in deliberative democracy. In addition, and as I've already explained, the Scottish Parliament can hold referendums to ascertain the views of the people of Scotland on particular issues, and it has a regulated process for holding referendums under the 2020 Act. So the devolution settlement reflects a mixture of principles of representative, deliberative and direct democracy, and also reflected in the fact that devolution settlements for Scotland and Wales now declare that the devolved institutions can only be abolished on the basis of a referendum of the people of those countries. In that respect, I refer to section 63A(3) of the Scotland Act and the Government of Wales Act, section A1, subsection 3. The Northern Ireland Act of 1999, in implementation of the international legal obligations under the Belfast Good Friday Agreement, includes a referendum requirement in respect of Northern Ireland's place in the UK, and that is section 1 of that Act. So given these features of the Scotland Act and the manner in which the devolution settlement operates, there are reasons for concluding that the Scottish Parliament is not constrained when ascertaining the will of the Scottish people, and that it can do so even where the question is concerned with the subject matter of a reserved matter. Notably, both of the citizens' assemblies referred to above produced recommendations concerning reserved matters. Such matters, merely by dint of being reserved, are not as such no-go areas for the Scottish Parliament or the Scottish ministers, and they're entitled to ascertain the views of the population on them. If they could not do so, the Scottish ministers would be precluded from consulting the people of Scotland on a wide variety of issues, whether by referendum or other form of consultation exercise. By way of example, casinos or daylight saving time provisions. These are in B9 and L5 of Schedule 5. These are reservations. So they couldn't, for example, consult the Scottish people on whether or not the way in which our clocks operate in Scotland, which can sometimes be challenging for young people going to school in the morning during the winter times, they couldn't consult on whether or not there is a reason to consider that there should be at least some discussion with the UK Parliament about changing daylight saving time. So I say that the Scottish ministers, it can be argued, are not precluded from consulting the people of Scotland on a wide variety of issues, and they are not precluded to consult the people of Scotland on the issue of independence. So to summarise my points, the words and provisions of the bill indicate that the legally relevant purpose is to ascertain the wishes of the people of Scotland on their own future. The wider motivations and aspirations of the Scottish Government and other political parties are not legally relevant. The legal consequences of the bill are relevantly nil. Any practical effects beyond ascertaining the views of the people of Scotland are speculative, consequential and indirect, and should not be properly taken into account. It can therefore be argued that the purpose of an advisory referendum, such as prescribed in the Scottish Independence Referendum Bill, has at best an indirect or consequential connection. I refer to the Welsh asbestos case at paragraph 27, and so it has at least an at best indirect or consequential effect to the Union, and it doesn't have a direct or short-term effect. And I refer there to Imperial Tobacco against the Lord Advocate in the Inner House at paragraph 133. It doesn't have the connection or involve some practical impediment or other effect necessary for it to be outside competence. So even if the criteria included purposes that had a loose or consequential connection to the Union, ascertaining the wishes of the Scottish people with its purely indirect, contingent and speculative consequences for the Union would be insufficient to satisfy the test. So can I then conclude on the issue of the reservation of the Union? Whether the referred provisions relate to the reservation of the Union depends to a significant extent on how broad a meaning is given to the effect of any referendum within terms of section 29(3). If its effect, for the purpose of determining whether it relates to the reservation of the Union, embraces the political consequences of any yes vote, then it may be beyond the competence of the Scottish Parliament. If, however, its effect is determined by its legal consequences and immediate effect, obtaining the views of the Scottish people on the subject matter of a reserved matter, then it may not relate to the reservation and thus would be within the competence of the Scottish Parliament. So then, moving on to the arguments as to whether or not the referred provisions relate to the Parliament of the United Kingdom, in that respect referred to Schedule 5, Paragraph 1c. Paragraph 1c of Schedule 5 identifies that the Parliament of the United Kingdom is a reserved matter. In Legal Continuity Bill, it was held that the reservation encompasses the sovereignty of Parliament, and I refer there to Paragraph 61. So the argument that the referred provisions relate to the reserved matter of the Parliament is as follows. If Scotland became independent, this would involve a reduction in the scope of the UK Parliament's powers, and I refer to Muan at page 672 at paragraphs 17, 71, 91 and 102. Indeed, if Scotland became an independent country, members would no longer be returned to the UK Parliament from Scotland, and it would become the Parliament of England, Wales and Northern Ireland. The purpose of holding a referendum on independence, even though it is advisory in nature, would be a purpose that relates to such a diminution in the power of the UK Parliament for essentially the same reasons that I have given in relation to the issue of competence. In relation to the case that the reserved provisions do not relate to the Parliament of the UK, the argument that the referred provisions do not relate to the reserved matter of the Parliament is as follows. The Legal Continuity Bill case made clear that the reservation of the Parliament of the UK is not infringed in circumstances where the authority of the Parliament to change the law is not affected. It therefore dismissed a submission that Section 17 of the UK withdrawal from the EU Legal Continuity Scotland Bill, which would have made specified delegated EU legislation dependent on the consent of the Scottish ministers before it could take effect in Scotland, related to the Parliament of the United Kingdom. This court at paragraph 63 held, nor are we persuaded that Section 17 impinges upon the sovereignty of Parliament. Section 17 does not purport to alter the fundamental constitutional principle that the Crown in Parliament is the ultimate source of legal authority, nor would it have that effect. Parliament would remain sovereign even if Section 17 became law. The court preferred to analyse any practical impacts on the ability of the UK Parliament to realise its policy goals by reference to Section 28(7 by means of Schedule 4. At paragraph 64, the court makes reference there, but the provision of Section 28(7 doesn't arise on this reference. But since the proposed bill would establish only an advisory referendum, it would not purport to restrict the powers, authority or jurisdiction of the UK Parliament. It would not be analogous to the UK withdrawal from EU Legal Continuity Scotland Bill in having direct legal and practical effects on the UK legislation. Changes to certain of the Articles of Union can only be effected by the UK Parliament. That's paragraph 1(2) of Schedule 4 to the Scotland Act. And the UK Parliament's constitutional role is entirely unrestricted by an advisory referendum. In the words of this court in Legal Continuity Bill, the proposed bill does not purport to alter this fundamental principle, nor would it have that effect. So I would wish to make some concluding observations then, having taken the court through these arguments. Since 2007, at 4 successive Scottish parliamentary elections, the Scottish electorate has returned governments committed to Scottish independence. Separately, at each UK general election since 2015, a majority of MPs from Scottish constituencies have been elected on the same manifesto commitment. Against that background and long-standing consensus that Scotland has the right to self-determination, to what extent, if at all, the holding of a referendum relates to reserved matter is a question of fundamental, constitutional and public importance. Despite the highly charged political debate, it is a question of law. It is therefore a question that can only be authoritatively determined by this court. I believe it's in the public interest that clarity be brought to the scope of the Scottish Parliament's power in respect to this issue. Accordingly, the Lord Advocate in Scotland has invoked for the first time the right under Scotland Act to refer to this court a devolution issue which is not currently the subject of litigation, and it's done so for the benefit of the Scottish Parliament, the Scottish Government and the people of Scotland, and indeed people throughout the United Kingdom. The outcome of this reference is of particular importance to the Scottish ministers who have sought to, who would wish to introduce a bill on the referendum question if an answer to the reference is given in the negative, and that would be very much their wish. But it is, in this case, a matter that I bring before the court as a result of my retained function as a Lord Advocate, and I seek the court's ruling in order to inform this critically important question. There are two issues, I think, that arise from earlier on today that would require some answer, and it may be that we need a little bit more time to do some further investigation. I was asked for whether or not there was some information available to indicate why it was that the paragraph 1F of the schedule to the Act relates only to questions about reserved matters. This was looked at before the case, and in researches we came across internal communications between the UK Parliamentary Council and the Scottish Office, and we do have communications between these two offices in relation to this matter. But there really is no assistance from the parliamentary debate or the internal materials. And I submit that it's reasonable to suggest that paragraph 1F reflects recognition by the Parliament that it's not possible to foresee all circumstances in a question about a reserved matter could arise, and an intention to capture all such circumstances without exception. One possible explanation for 1F not extending beyond reserved matters is that at the time of the legislation, reserved matters was a new concept at the heart of the devolution regime, in which no existing jurisprudence was available, and therefore in respect of which it may have been thought that there was a need for a particular provision under Schedule 6 to ensure that these questions could be brought for the consideration of this court.
I would have to look it up again, but didn't the original devolution to the Northern Irish Parliament in 1922, didn't it operate on the same model of reserve matters?
Yeah. So that's something that we've yet to look at, the Irish background, and it's something that we will do so.
Yeah. Okay.
We couldn't find any of the explanatory notes for what act was it? The Northern Ireland Act 1998, but we haven't looked any earlier than that. But we will undertake that exercise and try and do the necessary comparative exercise that might inform.
I was just concerned that the concept of reserve matters was slightly older than 1998, but I stand to be corrected. And
very well. Well, I suppose it was new for Scotland. That's possibly what I mean. So that's is that possible explanation? Is all I'm saying. But there's really no assistance from the parliamentary debate or internal materials. We'll continue to look, but there was quite an exhaustive search done before today on that. Lady Rose asked a question of whether or not a member's bill could be challenged under paragraph 34 of Schedule 6. That's where a member chose to introduce the legislation and confirmed that in their view, it was within competence. I would answer this question by saying it really wouldn't arise in practice, as in practice, the Lord Advocate doesn't refer a bill until after stage 3 in that respect. But I wouldn't rule out that it could be challenged under paragraph 34 in the right exceptional circumstances. So it could be done, but in practice it really doesn't arise. And there's a particular involvement of the Lord Advocate at stage 3 in the private member's bill procedure for referral to the Supreme Court on a question of legislative competence.
Could perhaps it be helpful if you were to explain to us what the Lord Advocate's role is at stage 3?
Yes, so I can give that in writing. I do have.
That's more convenient.
I think that's possibly more helpful because it's quite. I do have some material here that could easily be prepared and handed up, along with, if we can get it, some further background material on the issue of schedule, the schedule to the Act and paragraph 1F.
And just to help me, stage 3, what does that mean?
So that's in relation to the point at which the bill has been introduced. It's gone through the relevant processes within Parliament in terms of debate, committee stage and amendments, and the final stage in the process is stage 3, and that's the stage at which the Lord Advocate would then consider whether or not, as a result of the terms of the bill or indeed any amendments, that the case should be referred to the Supreme Court in terms of a legislative competence issue. But I can easily give my Lord a flowchart on that.
I think I've understood from your explanation. Thank you.
Is that something different from the Section 33 process?
So this Section 33, I just need to check Section 33. It would be within that, yeah. I think it's part of Section 33 process, but it's just called Stage 3, I suppose. It's part of the process within Section 33 that there is the scrutiny of the bills.
As I understand it, stage 3 is essentially the temporal period defined in Section 33 and subsection 2.
Yes.
Right. Yes, thank you.
So unless there's anything else, those are my submissions.
No, we're most grateful, Lord Advocate. You follow the statement. Sir James.
My lords, my lady, I'm going to take the issues of jurisdiction and discretion together and try and focus the submissions a bit under that composite heading. The starting point we submit for the issue of jurisdiction in particular is that there is clear and consistent authority, including at this elevated level, that it is not appropriate for courts generally to engage with abstract questions of law until the facts are known. And the case law has made it entirely clear that the facts for this purpose include whether possible legislation will in fact be passed, what its precise terms will be, and indeed very often a factual matrix to which such legislation actually applies. That case law doesn't just identify those as the relevant facts for the purpose of the principle. It examines in some detail why the courts take that position. And I wanted to take you to 2 or 3 authorities, if I may, on those matters. The first of them is the Attorney General for Northern Ireland's reference in this court behind tab 12, starting at page 866. And the relevant page, sorry, it's maybe very inconvenient to give you the start page if you're doing it electronically. 872 is the page I actually want. And you'll see the sentence at the beginning of paragraph 28 at the bottom of 872. In general, it is desirable that legal questions be determined against the background of a clear factual matrix rather than as theoretical or academic issues of law. And then you'll see in the remainder of the paragraph, which I don't read out, the basic reasons for that. It was a theme to which Lord Kerr returned in the second of the Attorney General references. I don't take you to that second Attorney General reference now, because we've summarised the relevant bit in our case at paragraph 37. So that's the first set of cases, as it were. The second of them is a decision of Lord Justice Lloyd Jones, as he then was, and Mr. Justice Lewis in Yallen, to which reference has already been made. That is behind tab 56, and the relevant paragraph for our purpose is on page 3317 in the electronics. 3317. And as you see, para 25 says it will rarely be appropriate to consider such issues when they may depend in part on factual matters or future events, since until those factual matters are established or the events occur, the courts will not be in a position to know with sufficient certainty what issues do arise in a particular case. Similarly, when matters may depend upon or be affected by future legislation, it will generally not be appropriate to make rulings on questions of law until the precise terms of any legislation are known. And that paragraph with those principles and that explanation there set out was effectively dispositive on the facts of that case.
Well, in the circumstances of this case, there's a majority in the Scottish Parliament, and we're told that the legislation is going to be proposed, and surely we can take it it's going to be passed.
My Lord, I don't think you can, with respect, take that as read.
Why not?
People might have different views. MPs haven't yet voted. The mere fact that there's a government majority may lead to that result, and it may not. And my Lord shrugs your shoulders, so that's unrealistic. It's a matter for you to take into account. But normally the views of courts are that even if a government has a majority, and even if a government is proposing legislation, it doesn't necessarily follow that it will be passed at all, and if it is, will necessarily be passed in precisely the terms in which it sits when it's introduced.
This is, in essence, a very short piece of legislation, and one can hardly imagine fundamental changes to the question or to the operative parts of it.
Well, my Lord, you may very well be right. I simply don't know. There may be operative parts that get changed by way of amendment, there may not. In any event, I'm simply on the principles at the moment rather than necessarily how it applies here. I don't want to diminish the force of the point my Lord puts to me. I'm not entirely unrealistic. It is a short piece of legislation, and I suspect that on both sides' cases the issues that would arise at the later stage in relation to competence will arise come what may and irrespective of the precise form of question. So I'm not seeking to deny that. This is in large part, as it were, a setup to the submissions I'm going to make, which are of broader significance in this case, about how jurisdiction works under the Scotland Act, where you will need to bear in mind not just the facts of this case and the potential clarity of the legislation, but more generally how the Act works, and in particular the interrelationship between Section 31.1 and Section 1, Paragraph 1F of Schedule 6. That's the key bit for present purposes, and that's a bit that isn't confined necessarily or at all to this particular piece of legislation. So that's the broader answer of principle. The third of the authorities I wanted to show you to involve one of the members of the court in Yallen, but not the other. By this point, Mr. Justice Lewis had become Lord Justice Lewis and was sitting with Mr. Justice Steyn in Counsel General for Wales, tab 59, page 3530. And the relevant paragraph for present purposes is paragraph 33, starting halfway down, a little over halfway down, page 3530. Can I invite the court to read to yourselves that paragraph? Quite a long paragraph, but maybe more convenient to read it to yourselves. So you see the themes. Governments, law officers and everyone else, and legislatures must inevitably form their own view about whether proposed legislation is compatible with various superarching pieces of legislation, e.g. the HRA. There's nothing new or surprising or unfortunate that the courts get involved only after legislation is enacted and not before. And the reason for that is because courts do not, in general terms, for all the reasons I've gone through, give advisory declarations in the abstract. The court specifically noted in that paragraph, as you've seen, that the equivalent law officers and the presiding officer in Wales were likely to have to form a view about competence and reference, but they do not seek advisory declarations prior to the passing of bills. So that's the critical paragraph for present purposes from Counsel General Wales, and you will note that the Court of Appeal dismissed the appeal. I don't need to go to that dismissal for present purposes. If you wanted, it's at page 3562 in the authorities bundle. And since the service of our written case on this reference, i.e. this reference, this court has refused the Counsel General permission to appeal further to this court.
But, I mean, in our case, might it not be said that it's not going to be an advisory declaration and it's not in the abstract? I mean, if the court rules on the matter, it will be deciding the point in the context of this bill, won't it?
My Lord, it will, but it will be deciding the point in the context of a draft bill that hasn't been introduced into the Scottish Parliament and has yet to go through those processes. And I'm going to take you through the processes that the Scotland Act envisages before a reference in relation to a bill can be made. So, my Lord, I don't seek to suggest that this paragraph is directly on all fours, and I fully take the point you put to me, but this is the basic rule, and the purpose of taking you to these authorities is not to say we are in pari materia. It is to say this is the basic starting point, well known, well established, against the backdrop of which Parliament then legislated in the Scotland Act to set up what we will submit is a limited set of circumstances in relation to draft bills where Parliament, where the courts can do precisely the thing they wouldn't otherwise do, namely to give a view about the competence to pass particular as yet unenacted legislation. They take it to the final stage of passing and then the courts get involved. So the Scotland Act 1998 and the equivalent other pieces of devolution legislation represent an exception, and we submit a narrow and carefully circumscribed exception to what otherwise would be the basic principle as adumbrated in these cases. That's how we've got that point.
It's an exceptional jurisdiction in a number of ways. In also the fact that that this court is exercising an original jurisdiction.
Yes.
In proceedings which can only be initiated by law officers.
Yes.
It's very much giving this court a constitutional jurisdiction. So it's somewhat different from, well, for example, the judicial review proceedings in the Counsel General case.
My Lord, it is. And as I say, I don't seek to rely upon these cases being in pari materia. They're obviously different. You've got to deal with a specific constitutionally centred original jurisdiction that is set out in the Scotland Act. The question is, how far does that go?
Yeah.
That's the ultimate question of interpretation, which is the issue you're going to have to grapple with. Keating's, I was going to refer to as the final in the quartet of cases establishing the general principle, might be thought to be a little bit closer to our sort of situation, particularly in relation to the facts. And Keating's is behind tab 14, and the relevant passages for present purposes start on 899. And again, I don't invite you to go through them all now, but you will see from the reasoning of the court, this is Lord Carloway, the reasoning of the court at paragraphs 51, and particularly 51 through to the end of 55, reject the attempt to inveigle the court into ruling on the draft piece of legislation for a referendum of the kind that we're concerned with, and they did so on the basis of those traditional principles. There were lots of imponderables in that case, including whether or not a bill would in fact be introduced and how it was going to turn out. And many of those imponderables do at least have some resonance here. The bill hadn't been introduced. As the court put it, a draft bill has no legal status. If introduced, a bill may or may not be passed by the Scottish Parliament, said the court. The form of the bill introduced may be different. No matter what its initial form, said the court, it may be amended. Now, again, it could have been said to those representing the Advocate General in that case, well, isn't it obvious? They've got a majority. It's a pretty straightforward piece of legislation, but they were imponderable enough, at least for that purpose, to lead the court to the conclusion that you see set out at paragraph 55.
I thought at that stage the result of the election wasn't known.
My Lord, it wasn't. So there were more imponderables here, as I entirely accept. Yeah. But the ones I identified just now were taken as imponderables, as it were, from the reasoning of the court, as you see in paragraph 55. So we do submit that that basic principle is the key starting point, at the least, in considering the meaning and effect of the Scotland Act, and is important in considering discretion if you get to that stage. I wanted then to turn directly to the Act, recognising that this is a question of interpretation of the Scotland Act, with all its status of the kind my Lord the President has just reminded us of. And so far as the Act is concerned, I wanted to make two key initial points, if I may. And the first is that the legislation, that's the Scotland Act, sets out a carefully regulated and specific timetable and set of requirements before a reference can be made of a bill. So if you go into tab 1 of the authorities and get the Scotland Act, if I may, can I just remind you of the key provisions so far as this is concerned? The position essentially is that the bill must have been passed or approved in accordance with any standing orders that are made under section 36(1) and 5. I take that from section 33 sub 2 on page 141. So the power to make a reference is given to the law officers that my Lord the President identified. That's 33(1). May refer the question whether a bill or any provision of a bill would be within legislative competence. And we know what that means. That means the section 29(2) question. In other words, the various bases on which it will be outside that competence. And then sub 2, subject to subsection 3, he may make a reference in relation to a bill at any time during the period of 4 weeks beginning with the passing of the bill, and then any period of 4 weeks beginning with any approval of the bill in accordance with standing orders made by virtue of 36(5), which we'll look at in a second. So the basic position is that there can be no reference by the law officers under the scheme of this legislation until the bill has passed. And then there's a set period of 4 weeks within which the reference has to be made. So passing is the necessary and the mandatory temporal precondition to the making of a reference. What then are the stages of the bills before you get to that point? Go forward, if you would, to page 146 and have a look at section 36. What this does is to make mandatory provision for the content of parliamentary standing orders of the Scottish Parliament. Standing orders shall include provision, as you see from 36(1), and then you see the various stages for general debate on a bill with an opportunity for members to vote on its general principles, for consideration of and an opportunity for members to vote on the details of the bill, and for a final stage at which a bill can be passed or rejected. So all of those things have to happen before the trigger in 33 for a reference can be made. And that's for a pretty obvious reason, which is to thrash out the content and actual detailed nature of the bill before any power to make a reference is made. You will then see, and we don't need to trouble too much with it, but you saw reference to 36(5) and the approval process earlier on in the provision I took you to, and you will see that 36(5) is effectively a reference back to 36(4). I'm not going to go through the intricacies of that, but it is at least worth chasing through those procedural intricacies as the alternative to passing as the trigger point for a reference. In a specific type of situation, you've got to have standing orders making provision for various other sorts of process that have to be gone through before the reference trigger point is reached. They are, in essence, and in very broad summary, matters where the subject matter of the bill are to do with how you get elected to the Scottish Parliament. So there is an intricate scheme for standing orders to regulate those parliamentary stages, and they include provision, as you see, for detailed consideration of bills by the Scottish Parliament. The prescribed legislative stages include specified opportunities for legislative reconsideration after the Supreme Court determines any reference. So there's provision made in this Act not merely for the process that leads you to the reference jump-off point, but there are also provisions in the legislation that deal very specifically with going back to the Scottish Parliament after the Supreme Court has determined a reference. See, for that purpose, section 36, sub 4, standing order shall provide for an opportunity for the reconsideration of a bill after its passing if and only if the Supreme Court decides that the bill or any provision of it would not be within the legislative competence of the Parliament. So in other words, if you assume introduction, they pass, the statements are made, the bill is prima facie deemed to be competent, it comes to the Supreme Court. The Supreme Court disagrees, says no, that provision and that provision and that provision are not within competence. Standing orders have then got to provide for a process, or at least for the opportunity for the Scottish Parliament to reconsider. So that's part of the built-in process. All of those processes presuppose that the draft bill has gone through the first essential stage of introduction. And I'll come back to that because section 31 and how it works is at the heart of the interpretive debate that you will have to grapple with. But all of those stages, as I say, are preceded by the requirements for the various statements and the offering of views. Then it gets introduced, then you have the standing orders, then you have come back if the Supreme Court decides any part of the past legislation is in fact outside competence. You will also have noted, now the President reminded us of it a minute ago, that as part of that intricate structure, only specified office holders can refer. See section 33, sub 1, at page 141, and they are the Advocate General, the Lord Advocate, or the Attorney General. You will also note, just to complete the intricacy of the process, section 32 sub 2, which is part of the provisions governing references and so on, and entirely obvious why this provision needed to be made. 32.2 is on page 137, and what it does is to preclude the presiding officer from submitting a passed bill for assent if a reference is made within that 4-week period. You can see why you would need that, because otherwise the bill was submitted for assent before the Supreme Court had offered the constitutional view on competence. So the key point to be derived from this suite of provisions, with all their care and intricacy, is that the United Kingdom Parliament in the Scotland Act has required that the stages of the legislative process in the Scottish Parliament be completed. The legislation specifically sets the end of that Scottish parliamentary consideration as the trigger for the 4-week window referred to in section 33.2. And the clear intention is therefore, at this stage, that the bill in the Scottish Parliament has gone through all of its legislative stages, all of those stages referred to in 36.1, so that it is in final form and simply awaiting assent. That's the only thing that needs to happen, is His Majesty needs to put the chop on it. It is the point at which the issue, therefore, bear in mind at least the basic themes from the case law I took you to earlier, it is the point, legislatively, it is the point at which the issue that will come before the Supreme Court is as close to not being abstract or inchoate as possible. You've done everything apart from His Majesty putting his chop on it. You will also note, as part of this legislative structure, and it is just a note, that there are relevant provisions within it, and provisions specifically made for orders in council to be made that would specifically modify both of Schedules 4 and or 5. You see that from section 30 sub 2 on page 131. And that was a point that was noted by the Lord President in Keating's at paragraph 55. You may have picked up that reference in paragraph 55 of Keating's to that power. And it was that section 30 power which was used to make the order in 2013 modifying Schedule 5, the bits that we're worrying about when we get to that competent stage, so as to permit the referendum which took place on the 18th of September 2014. The order, if you want it, is at tab 36, page 2164, but it followed, as you will recall, a political agreement that was reached between Her Majesty's Government and the Scottish Government in 2012, which you also have in the bundle. But section 30, for present purposes, sits as part of that scheme. You can change it if you want to, but it has to be done by that process, which is specifically provided for. So that's the first point I wanted to draw attention to in relation to the Act. It sets out a carefully regulated and specific timetable and set of requirements before a reference can be made. You can't just do it willy-nilly. It's very carefully done, and it's very carefully done with an eye to all of the line of case law I took you to earlier. It sets the time point for jumping off at the point where the legislation is in effect final apart from assent. Second point in relation to the legislation, it is also evident, and Parliament, that's the UK Parliament, will have appreciated this fact as well, that a variety of documents are likely to be created before introduction of a bill into the Scottish Parliament, and those documents will normally accompany the bill at introduction. So, explanatory notes, policy memoranda, committee reports, and so on. I say will normally, under the Scottish Parliament Standing Orders Rule 9.3, any bill must be accompanied by a financial memorandum and explanatory notes, and a Scottish Government bill has also got to be accompanied by a policy memorandum setting out the policy objectives. See page 6441 in your authorities bundle. And this point is of interest because those sorts of documents, which may be perhaps, to come back to Lord Stevens, less necessary in the context of a simple bill with a basic purpose like this, but might be very, very important in relation to more complex legislation, which this scheme will have to govern as well, and whatever view you take on 31.1 and its relationship to Schedule 6, paragraph 1, will also have to work for. It's of interest because these sorts of documents have long been held in your case law to be particularly important as informing the consideration of whether or not the bill or a bill and its provisions are within competence. And that is no doubt because 29.3 puts the spotlight squarely on purpose and effect.
Can you just please give me the page reference again for Rule 9.3?
6441.
Thank you.
Is that one. And the importance of these sorts of documents, again, it's trite, so you probably don't need a reference, but if you wanted one, Martin and Most per Lord Hope at paragraph 25, page 397, but we've given you a host of other cases, no doubt unnecessarily, in our case at paragraph 13, which are references to the same end. The point is that those sorts of documents are likely in many cases to be integral to the consideration by this court of competence and therefore the fulfilment by this court of its constitutional role. And they will be lost.
And do those documents also include party political manifestos and statements by, on behalf of a political party?
My Lord, I'm not sure that those documents referred to in the Standing Order Rule will include those sorts of documents. But I don't think, if that's the purport of your question, that there's been anything in the case law, as it were, that limits for this purpose the source but from which you might derive assistance as to purpose. Does that make sense as,
Yes,
as
indeed.
an answer? So the reason that the legislation goes into this level of careful detail, setting out the pre-enactment safeguards, is obvious. The United Kingdom Parliament clearly recognised that lots can happen to a bill during legislative stages through the Scottish Parliament, including those that must be set up under the standing orders, given the requirements of section 36(5) that I've taken you to. Those processes affect the shape of what can then be referred. The legislatively inchoate must become coet. The United Kingdom Parliament also clearly recognised that if references are made in compliance with those safeguards, the issues that the Supreme Court will need to consider will then be capable of being considered with maximum certainty and with the maximum degree of assistance that can be provided to the important constitutional role, and indeed, to hark back to my Lord President's point, to the original jurisdiction that this court is then having to undertake under the section 33 reference process. And all of this, we respectfully submit, was clearly and squarely recognised, i.e. all of this being the basic design and structure of the legislation, by Lord Carloway in Keating's, see in particular paragraph 60 at page 901. So perhaps to finish today, can I just make twin submissions at this point in the argument? The twin submissions are, first, that Parliament has been prepared to countenance a departure from the usual approach of abstinence, judicial abstinence, but has done so on terms. As a general rule, you don't give advisory opinions on hypothetical provisions in the abstract, still less on proposed legislation, because, or not least because, that draws courts into policy making and legislative functions in a pretty uncomfortable way, and you need, therefore, the clear parliamentary authority that you have in the Scotland Act to enable that process to be undertaken. So the devolution legislation gives you, as it were, that legislative permission, but it does so in a very carefully delimited way that has obviously been designed with an eye to that case law, because all of the thrust of all of those provisions is to try to make as certain as can possibly be done that by the time it gets to you, the Act is in as final form as can possibly be mustered prior to it actually becoming law. And the second submission, which I leave you with for the purpose of today, is that with respect, the Lord Advocate's interpretation of the tail end and unspecific words that finish off Schedule 6, paragraph 1F, bypasses / undermines all of that. It is no answer to that point for the Lord Advocate to say, as she does, this is not a bill reference, so section 33 is irrelevant. The Lord Advocate has carefully and deliberately chosen to frame her referred question around the terms of a draft bill. She's no doubt done so to try to reduce the force of the argument that it seeks a judicial ruling in the abstract, but the fact that it is not a bill reference under section 33 is nothing to the point. Of course it isn't. But that is no answer to the objection that referring a draft bill at this stage, which has not reached the section 33 stage, circumvents the exclusive statutory scheme that Parliament has gone to all that trouble to set up, with all the demerits that that process, or that jumping of the process, entails.
How do you get to the section 33 stage if you cannot genuinely make a section 31 statement?
My Lord, my answer to that, and I'm going to come back to it in more detail tomorrow as the next topic when I consider how section 31 fits into this scheme, my ultimate answer to that question, given the time, is so be it. Parliament has set up a jurisdictional precondition to the introduction of a bill into the Scottish Parliament, which is that you need to be able to persuade, I was about to say even, but that would be disrespectful, even your own law officer. You can't even persuade your own law officer that you are within competence. the shutters come down under the scheme of this legislation? That's our ultimate answer to that question. But I'll return, if I may, in a little more detail to section 31 tomorrow.
Well, in that case, we'll adjourn there for the day and resume at 10:30 tomorrow morning.